Lordships may just recall that in a previous order which was passed by this court, the Constitution Bench has held that no other court should entertain petitions, etc. So that's one order which I wanted to draw attention to. And all applications and petitions should be filed in this court alone. That's one order. The other order is when separate writ petitions came to be filed because of this direction which was passed by this court. What your lordships thereafter ordered is that we are disposing of the writ petitions, but we are granting liberty to each of the writ petitioners to file an intervention application to assist the court and the Constitution Bench. So those writ petitions were also closed, allowing us to approach this court because probably you didn't want a multitude of writ petitions to be filed, and that is the status. So we are entirely in the court's hands, but I thought it may be useful to go through these orders first, and thereafter, of course, as your lordship suggests, proceed sequentially or whatever manner the court considers appropriate. So I was just seeking permission of the court if you would allow me to place these orders as they evolve so that we at least know the orders which have been passed by this court coming to this moment. That is my only request.
Mr. Shyam Diwan,
yes,
you have also discussed
very well
before coming, right?
Yes, yes.
Now, if the issue has really become academic,
yes,
there is no point in wasting the time of 5 judges.
Yeah.
Right? Now, we feel having regard to the passage of time.
Yeah.
If there is any individual grievance in any separate writ petition, we will tackle them.
Yes.
But otherwise, all these issues should we take it up at this stage.
It's not academic, it won't be academic because as I'm now just on the last point which you correctly observe. If there are individual issues, the individual issues challenge will be at different levels.
Yes.
They will be at the challenge that, look, this particular statute is unconstitutional. Assuming it is constitutional, the action under the statutes is for whatever reason disproportionate, failing constitutional tests. So, as your lordship is aware, our challenges are layered. They are at different levels. So, there is an attack on the validity. Assuming the validity, as your lordships correctly hold. One thing I might just point out, I mean, it's just maybe of some interest because Mr. Chidambaram has already indicated that to the court.
Yes.
As far as the 77-78 demonetization is concerned, and we have placed that in the compilation, that decision eventually came in 1996 by a Constitution Bench, which examined threadbare the statute and thereafter went into the individual grievances and pronounced on the individual grievances by the Constitution Bench itself. So that judgment also we have placed in the compilation. So, I mean, not that that is binding on your lordships in the sense, but that's an indication as to how a previous Constitution Bench tackling an issue similar to this did proceed in the matter. They retained the matter and they eventually decided it. So, Manoj, I am only speaking now from the perspective of the individual whom I represent. We had filed a writ petition. This court said that please file an intervention in this lead case of Vivek Sharma. So that petition was disposed of. We availed that liberty and we have come here by way of an application, etc.
That, Mr. Shyam Diwan,
yes,
with due respect,
yes,
that was a time perhaps that order was necessary.
Yes, maybe.
Now everything is settled down. Yeah, yes.
1978 demonetization was by a separate legislation of Parliament. Ordinance on
use them.
Sorry. The 1978 demonetization was by a separate law of Parliament. Ordinance followed by an act. Now, earlier in 1948 or so, there was another demonetization by a separate act of Parliament. Today, they have used the Reserve Bank of India, sections 24 and 26. Now, whether a demonetization of this kind, we will show it is really not demonetization. It is new notes for old. It is really not demonetization in the sense that any currency is declared legal tender. Whether a demonetization of this kind requires a separate law, debated in Parliament, ordinance of course, but debated in Parliament, and then Parliament could have modified it. Can you invoke 24 and 26? That's not academic. That is a live issue. And tomorrow, if this goes unchallenged or unadjudicated, they can invoke 24 and 26 today. Again, whereas the two previous examples of demonetization were by separate act of Parliament. And my submission will be this kind of demonetization